The deadline has now passed for the Department of Justice to respond to the nationwide block on the ATF's pistol brace and short-barreled rifle, SBR, rule. Meanwhile, the Fifth Circuit Court has officially scheduled oral arguments in this crucial case. There are some significant updates in the ongoing legal fight against the ATF's current stance on pistol braces. Right now, a nationwide vacatur is in effect, alongside several preliminary injunctions that continue to protect specific organizations, their members, companies, and customers from enforcement of the rule. However, with a new administration in power and a recent executive order from President Trump aimed at defending the Second Amendment, the Fifth Circuit decided to pause the Mock v. Garland case, now known as Mock v. Bondi. The court granted a 30-day abeyance at the request of the Trump administration, which wanted more time to determine how it planned to handle the issue moving forward. That 30-day period ended on Monday, April 14th. By that point, the Attorney General's office was expected to file an update with the Fifth Circuit on how they intended to proceed. But as of now, nothing has been filed on the docket. In response, the Fifth Circuit has taken matters into its own hands. Oral arguments in this pivotal case are now scheduled for the week of August 4th. This likely signals that the court has received some form of communication from the Attorney General's office, indicating they will continue with the case. If that's true, it could be a concerning sign, possibly hinting that the new administration is choosing to push forward on this issue, despite earlier signals of support for Second Amendment protections. For those closely following this case, and for all who care about firearms rights and regulatory overreach, this is a development worth watching closely. Stay tuned. Things are moving quickly, and this case could set a major precedent. Major legal victory against ATF pistol brace rule. What comes next? Recently, the ATF has suffered a series of legal setbacks in several ongoing pistol brace cases. Multiple preliminary injunctions have been granted against their rule, and now, in a major development, Judge O'Connor has issued a final merits decision in the Mock v. Garland lawsuit, striking down the ATF's pistol brace rule nationwide. In his decision, Judge O'Connor clearly stated that the final rule should be treated as a legislative rule, not merely an interpretive one. He explained that the final rule was not a logical extension of the original proposal, and because of that, it must be set aside as unlawful or remanded for correction. This ruling effectively invalidated the entire rule across the country. In response, the ATF chose to appeal the decision to the Fifth Circuit Court. All legal briefs in the case have already been submitted. The appeal was initiated under the previous administration, the Biden administration, which strongly opposed Judge O'Connor's ruling and wanted to keep the pistol brace rule in place. At that time, oral arguments were still pending. However, with the recent shift in administration, that has changed. After taking office, the Trump administration informed the Fifth Circuit that they needed time to reassess how they wanted to handle the case. They requested that the case be temporarily paused. That request came directly from the Attorney General's office, citing President Trump's February 7, 2025 executive order titled Protecting Second Amendment Rights. The order directs the Attorney General to conduct a full review of all actions taken by federal agencies that might infringe upon the Second Amendment. It also instructs the Attorney General to develop a plan of action and report back to the President through the Domestic Policy Advisor. Importantly, the executive order specifically calls for a review of all rules issued by the Department of Justice and the ATF from January 2021 through January 2025 that pertain to firearms and federal firearms licensees. This review could have far-reaching implications, not just for the pistol brace rule, but for any regulation passed under the previous administration that may be seen as infringing on gun rights. The outcome of this review, and the Fifth Circuit's eventual ruling, could reshape federal firearms policy moving forward. Following recent developments, the government formally requested a 60-day pause in the case to allow time for review of the challenged pistol brace rule. According to their filing, the purpose of the delay was to conserve both judicial and party resources and allow the current agency leadership to decide whether the existing rule still reflects their position. Essentially, it left open the possibility that the new administration might shift its stance from the one taken by the previous administration in this case. The Fifth Circuit granted that request and paused the case. But now, the 60-day window has expired, and we still haven't seen any update from the Attorney General's office filed on the docket, outlining what direction they intend to take. In response to this silence, the Fifth Circuit has decided to move forward. The court has now scheduled oral arguments in the case for the week of August 4th. This move suggests the court may have received informal word from the administration that they still plan to move ahead with the case and possibly continue defending the pistol brace rule. Meanwhile, there have been some encouraging statements from the AG's office on other cases. In the Peterson suppressor challenge, which is also in the Fifth Circuit, they've confirmed a change in legal position. The AG's chief of staff has even announced plans to investigate certain jurisdictions in California over delays in issuing concealed carry permits. These are positive signs that the new administration is reevaluating its stance on key Second Amendment issues. That said, none of this guarantees how they'll approach the pistol brace case specifically. As of now, it appears the court expects the case to move forward with oral arguments, since there's been no new briefing schedule or indication that the administration plans to amend their earlier legal filings. If they were planning to revise their briefs, we'd likely see something reflecting that on the docket. But so far, nothing. So for now, all eyes are on August. Right now, there's a serious effort underway to get the SHORT Act included in the Senate's budget reconciliation process. At the same time, the Hearing Protection Act just passed the House and is on its way to the Senate as well. If both of these bills were to make it through, especially the SHORT Act, and President Trump signed them into law, the entire pistol brace issue could essentially disappear. That's because under the SHORT Act, short-barreled rifles would no longer be treated as NFA-regulated items. So if you're looking for a way to bypass this whole pistol brace mess once and for all, the best thing you can do right now is pick up the phone and call your senators. Let them know you support both the Hearing Protection Act and the SHORT Act. The U.S. Capitol switchboard number is 202-224-3121. Just ask for your senators and leave a message supporting those bills. It's also important to understand that the ongoing case in the Fifth Circuit does not currently affect the nationwide vacatur of the pistol brace rule. That decision, handed down by Judge O'Connor, still stands. And it will continue to block enforcement of the rule until the Fifth Circuit issues a ruling or the Trump administration takes some kind of action on it. It's possible that the oral arguments scheduled for August 4th might not even be necessary. The administration could choose to resolve this outside of court. After all, we just saw them reach a settlement in the FRT rule case. While that agreement raised some concerns, it could signal a willingness to work out a resolution on the pistol brace rule as well, rather than continuing to fight it in court. That said, there's also an argument to be made for letting the Fifth Circuit move forward with the case. A strong ruling from the court would establish binding precedent in the circuit, which would still be valuable down the road, especially if future administrations try to bring the rule back or pursue similar actions. And if we don't end up getting the SHORT Act passed, a court ruling becomes even more important. So that's where things stand right now. The pistol brace rule remains blocked nationwide. The case is set for arguments in August, and legislative efforts are moving forward in Congress. As more details come out or if the administration makes a move, I'll be sure to keep you updated. Thanks for watching. And don't forget to like, comment, and subscribe for future updates.